wabarakatuh, and a very good morning I bid to our respected lecturers, Sir Amir Bakar. We are from Group 10. We'll be representing on the admissibility of similar facts evidence in Malaysia and also the common law cases and its principle. I am Nur Nashuha binti Ahmad Rizal, together with my colleagues Atiq Zulhami bin Supandi, Khairunisa binti Zainuddin, and Nur Alwani binti Ahmad Tajuddin.
For our group, the question is, the cases at common law that develop the so-called rule in making seem to have lost sight of the rationale of the similar fact rule by identifying fixed categories for which such evidence would be admissible, to the exclusion of all else that could not fit into these categories. Such an approach would not admit evidence when probative if what is was probative or was not within a recognized category. Worse, evidence not probative but within a recognized category would be technically admissible. The common law has since steered itself away from such absurdity. This much is clear from the decision of House of Lords in DPP against Boardman, where the approach of the common law is now to balance the probative value of the evidence against its prejudicial effect. Needless to say, this is more consonant with the interest of justice. In per Yang Pung Hao Court Judge in Tan Meng Ji against Public Prosecutor. Comment the above statement and to what extent it has affected Malaysian judicial attitude.
Similar facts evidence is the evidence that was originated from one common law cases named McKeans against Attorney General of New South Wales. Alright, I will first explain to all of you the facts of the case. In this case, a husband and a wife named John McKean and Sarah McKean practice as a baby farmers. Baby farmers is a practice where they take care of an illegitimate child in exchange of payment for their source of income. However, they had been using this modus operandi to take care of the babies, and also they kill the babies to deceive the parent, and they still get the payment from the parents. So in this case, the prosecution intended to adduce the evidence of the previous misconduct of the 13 babies that also been found buried in the back of the garden in their house. However, later, Mr. and Mrs. McKean were convicted for murder because the mother of an infant named Hori Mori come in front and make a police report for their lost son. And it was later discovered that at the house occupied by the McKeans were also found 13 bodies of the babies buried at the garden of their house. The judgment of this case had been laid out by Lord Herschel, the judge of this case. Well, in the first game, the judge disallowed the admissible of the similar facts evidence to be adduced as evidence. This is because mere to show that a person will repeat the misconduct again is not sufficient, because the criminal cases presume that a person is innocent until it is proven guilty. However, the second limb, the judge said that it is admissible to adduce SFE as the evidence if it is to show that the accident was designed or the misconduct was designed by the accused, and to rebut the defense raised by the accused, and also to rebut the defense that the accused may say that the misconduct is an accidental. In conclusion, the court had been very careful in admitting SFE or similar facts evidence in the sense that such evidence should not be admitted without reasonable cause. However, decided cases have suggested that the recent common law position on similar facts evidence is widely applied in Malaysia to the extent of disregarding the actual position of the Evidence Act 1950. Next, I would like to invite my friends Atiq Zulhami bin Supandi to explain more regarding the similar facts evidence in Boardman cases. Thank you.
Thank you, Nina Shuha, for discuss on what the approach taken by McKean case in explaining the rule of similar facts evidence. So for my part, I will discuss on the rule of similar facts evidence, but in the approach taken by DPP against Boardman. Okay, in this case, Actually, DPP against Botman represent a significant revolutionary on the rule of similar facts evidence. The House of Lords reformulated the rule relating to the admissibility of similar facts evidence from the court decision in the Makin case. So in this case, Botman is the headmaster of a school in England for international boy students to learn English. He was charged and convicted for the offence of burglary, or in our context is sodomy, for one boy of the age of 16 years old. And also he was charged and convicted for inciting a boy of 17 years old to commit the burglary. Both complainants gave the evidence which basically the same, where in the early hours of morning, the appellant would approach the victims and ask them to play the active role, while he placed the passive role in the appellant study room. In the appeal, the appellant challenged against the conviction where the trial court decided to admit the corroborative evidence of the both victims. However, the court dismissed the appeal as there were circumstances to the contrary of the general rule. The evidence of criminal acts on the part of accused, other than those with which he was charged, become admissible because of their striking similarity to the other acts that being investigated, and also because of their resulting probative force. Thus, the judge entitled to direct the jury as he had done. As we can see, in Botman's case, the question of admissibility of prior criminal acts or similar facts evidence must be determined by the judge in the light of degree of probative force possessed by the strikingly similar facts evidence. Here, probative value is eminently rests on the probability of rendered evidence to draw desired inference or possible material disposition, while striking similar is closely related with the quantum of probative value attached to the tendered similar facts evidence in determining the question of admissibility. However, it is subjected to the discretion of judges by applying their common sense guided to certain precise analogy or precedent. This reformulated rule required a high degree of relevance, which is very probative is required, where there is a striking similarity between the facts of one case and the facts of the similar facts evidence. And this striking similarity is something cannot be just a mere coincidence, because it is so striking have to be more than a mere coincidence, and to leave out similar facts evidence is not a common sense. In other words, there was distinctive modus operandi for the accused in committing the act in order to similar facts evidence to be admitted. As in this case, there was something similar between the boys' stories. The active and the passive role is striking, and in most cases of this kind, the older man will play the active role. So in this case, it was unique because it is the other way around. The evidence was therefore probative and not mere stock trade. To conclude, in Botman's case, the court stressing more on the ratio of cogency rather than the category enunciated in the Makin case. The principle of similar facts evidence reformulated by the judge in the Botman case has been adopted in many Malaysian cases, which I pass to the next presenter, Nisa. Thank you very much.
Thank you, Atiq Zulhami, for the explanation regarding the rule of similar fact evidence in the approach taken by DPP against Botman. Now, I will be discussing the application of balancing tests derived from Botman case in Malaysian case. But first, allow me to explain the background of the case. The case that I referred was the case of Tan Meng Ji against public prosecutor. The appellant was arrested for drug trafficking of paraphernalia. In this case, the appellant was caught by CNB officers who acted on the information that a person named So E was going to collect his supply of heroin at Fajar Road flat. The appellant went from Woodlands to Lei's house at Fajar Road to sell and consume the drugs together with several people in the house. He was later informed by Lei that CNB officers were searching for him at Fajar Road. Fear of being caught, he went out from the house, bringing the white plastic bag containing the drug. The CNB officers saw him in such condition and decided to follow him, which led to his arrest. Soon after that, the appellant had absconded from Selatar camp since March 1995 for the offence of drug trafficking and had never returned since that time. The prosecution relied on the appellant's previous offence of drug trafficking and related it with the current case on the ground of similar fact evidence according to Section 14 and 15 of Evidence Act.
In the case of Tan Meng Ji against Public Prosecutor, the Court of Appeal held that the mental state of the offender is a concern on such offence committed. The similar facts evidence in Section 14 and 15 of the Evidence Act only admit the evidences submitted in proving intention of the offence committed. The prosecution must balance the approach involving the prejudicial effect and balance of probative weight as the wordings in the Evidence Act on such matters will claim. The probative value must weigh more than the prejudicial effect for the evidence to be relevant under similar facts as stated according to Section 14 and 15 of the Evidence Act. The conviction of the appellant from the trial court was maintained by relying on the evidence of his oral testimony of the drug trafficking, not similar facts evidence of his previous conducted offence. The prosecution's submission on similar facts evidence regarding the previous crime of drug trafficking and the particular conviction of the appellant for the same offence was not relevant. Application from Mekin's similar fact rule is not applicable for the current case. Mekin's rule laid out specific and fixed categories for evidence under similar facts to be admissible. Any other evidence which does not fall within the categories will not be accepted. The effect of application of Mekin's similar fact rule to Tan Meng Ji's case would amount to prejudicial to the accused, since the offence committed was not probative. Application from Boardman's case is applicable in the current case on the balancing test. It requires connection between the evidence submitted and the issues before the court. The application of similar facts evidence in both Section 14 and 15 of the Evidence Act to apply the same balancing test done in Boardman's case. It requires the prosecution to do the balancing test to balance the approach involving the prejudicial effect and balance of probative weight.
As a conclusion, we can see that Section 14 and 15 of the Evidence Act applies the Boardman's principle of balancing test in the case of Tan Meng Ji against Public Prosecutor. Section 14 of the Evidence Act stated that it must be proven the mental state of the offender while committing the current crime as a subsequent commission of the previous crime. It requires the prosecution to prove that the previous offence committed by the offender was intended to correspond materially with the current crime. The fact that the appellant had committed drug trafficking prior to the particular case was not relevant to be admitted as a similar fact evidence as it does not correspond materially to the present fact. Section 15 of the Evidence Act stated that it must be proven that the act done is able to create a series of similar occurrences of the previous offence with the current case. The offence committed must be specific kind with the facts in issue and have similar nature between the previous offence to the current one. Applying the Boardman's principle to the case of Tan Meng Ji in Section 15, it requires the prosecution to prove that the similar facts of the previous act and the current act had contributed higher probative weight than the prejudicial effect from the previous crime. The fact that the appellant had been detained in Selatar camp on January 1995 for the offence of drug trafficking does not create series of similar occurrences with the arrest made on 1st August 1995. His conviction of drug trafficking is found from his oral testimony, not from the similar fact evidence of his previous offence. So, I'm done with explaining the case of Tan Meng Ji. We'll proceed to the second question with Nur Alwani.
So now, let's move to question 2. So, let's read the question first.
So for the question 2, Botak Singh went to Ajaib Hair Specialist for a hair transplant. After undergoing 3 treatments, the condition of his scalp became worse. Botak Singh sued Ajaib Hair Specialist for negligence, who denied this allegation. Botak Singh intended to call 3 witnesses to testify that they had gone for similar hair treatment with the defendant, Ajaib Hair Specialist, and all 3 had suffered similar disastrous results. Discuss whether Botak Singh could adduce similar fact evidence from the 3 witnesses. So for this case, we can extract 2 issues regarding to the main issues and also the sub-issue. The main issue in this case is whether Botak Singh can sue Ajaib Hair Specialist by adducing similar fact evidence on similar disastrous result from the 3 previous customer. And the sub-issue in this case is whether the evidence of previous conduct sought to be admitted is strikingly similar with the offence with which the accused is being tried. So, the circumstances or evidence in which the accused's previous misconduct called as similar fact evidence. So, what is similar fact evidence? Similar fact evidence, it is when it is made admissible to the court because of their similarity in the offence. So, it may refer to the modus operandi of an offence itself. So, generally, SFE shows previous misconduct of an accused to prove the current offence is not admissible due to the presumption in the criminal justice system that an accused is presumed innocent until proven guilty. Thus, the admissibility of the SFE must comply with certain principles established under common law, even though in some parts of the world. However, it can be tendered if it is relevant, as it needs to create a link between the circumstances from the previous event. Okay, so the first thing first, we need to look to the common law test, like what happened like previously, actually how the SFA came into enforce. So in the case of Boardman against PP, where instead of only considering at the similarity circumstances, the court said that it also must weight the probative value and the prejudicial effect. As in this case, the prejudicial effect was that the boys could work together to go against the warden. However, in this case, it was held that there was no conspiracy between the boys, thus prejudicial effect was not arise. And then moving on to the case of Harris against DPP, as in this case, the principle where the evidence of other occurrences which merely to show that the suspicions against the accused does not go to prove guilty, thus evidence of similar fact should be omitted unless such evidence has a really strong justification on the issues to be decided. So in order for the evidence to be admissible, it must relate to something more than isolated instances of the same kind of offence. So in the event if the court still want to apply a striking similarity test, so the probative value test can apply as well. So moving on to the application of SFE in Malaysia. So it can be further illustrated in Section 11 of Evidence Act, which stated that facts not otherwise relevant are relevant, subsection B, if by themselves or in connection with other facts that they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. So the word highly used in this section requires the element of probative force to be higher than what would normally be required. However, this particular provision is not meant for the admission of the SFE itself, because that's why it will make the existence of the section 14 and 15 will be redundant. Thus, we need to look into the section 14 of the Evidence Act, where it said that the facts showing the existence of any state of mind, such as intention, knowledge, and etc. Basically, the judges had incorporated the first task, which is the specific purpose task in this section. Thus, when the previous conviction is generally not relevant, but if the modus operandi becomes relevant, then the previous conviction would be treated. On the next section is stated about section 15, where the act was accidental or intentional in the event when the act formed part of series of similar occurrences. As in this case, the question is whether the act was accidental or intentional. In the event when the act formed part of series of similar occurrences will be discussed later in the cases mentioned above.
In the case of Azahan Muhammad Aminallah against PP, the court decided whether to admit similar fact evidence. There must be carried out a balancing exercise by weighing the probative value of such evidence against its prejudicial effects. In the course of the trial, the prosecution side had adduced similar facts evident of previous acts of sexual intercourse that was highly prejudicial to the accused. The Sessions Court judge intervened and asked the prosecution to justify how the course of the case took place. A trial court, in determining whether to adduce similar fact evidence, must weigh and balance up the probative value of the evidence against its prejudicial effect, as impliedly required in Section 14 and 15 of the Evidence Act 1950. Next, in the case of Nazarimi Sahib against PP, whether the similar facts evident relating on the accused action that sold dangerous drugs to the witness on the former three occurrences can be admitted as a similar facts evident under the particular section. It had been argued that the rationale of the rule excluding similar facts evident which every person charged with an offence may only be convicted upon being proved to have committed the acts within the charge. Thus, it is admissible in evidence provided the probative value of such evidence outweigh its prejudicial value.
Next, in the case of public prosecutor against Ali Asmat Yusof, the issue arose whether similar facts evident from other charge against the accused was admissible to the current charge. As in this case, the appellant did not tender on similar facts evident or any evidence of receipt pertaining to the corrupt money. However, in respect of the second charge was relevant and admissible to establish that the receipt of the RM 1500 was intentional and accidental, or to rebut a defense which would otherwise be open to the accused. Therefore, the appellant could not rely on the evidence adduced in respect of the second charge as similar facts evident that the respondent had corruptly received under the first charge. Next, in the case of Wong Kok Chun against public prosecutor, there was an evidence about the drug had been found in Nokia box can be accepted as evidence in this case. It was necessary because this constitutes as a part of the case on what happened during the day of incident. It has been argued above that the rationale of the rule excluding SFE is that every person charged with an offence may only be convicted upon being proved to have committed the acts within the charge. In other words, the probative value of the descriptions is to overcome the effect of harm on the appellant's case, and with that it can be accepted as part of the evidence the prosecution.
Referring to the case of Hales against Kerr, the plaintiff in an action of negligence alleged that he had contracted an infectious disease through the negligence of the defendant, a barber, in using razors and other appliances in a dirty and insanitary condition. As a result, it was dangerous misconduct, and the court satisfied that the witnesses' statements were admissible.
Okay, next, I will explain about the application on this case. So, by applying to this case, Botak Singh can adduce the similar fact evidence in the event when there was a similar disastrous result, similar with other three witnesses. So, based on the fact, Botak Singh had undergone 3 treatments, however, the condition of his scalp became worse. As in this case, the 3 witnesses also had been affected due to misconduct of the defendant previously. So, there was a negligence on part of the defendant that he might not sanitize the equipment previously, so it might cause an infection towards the other customer too. As I have been mentioned earlier, in the case of Hales against Kerr, this case was quite really similar with that particular case where the plaintiff in an action of negligence alleged that he had contracted an infectious disease through the negligence of the defendant, a barber, in using razor and other appliances in a dirty and insanitary condition. So due to the negligence on part of the defendant, it will result that it will constitute as a dangerous misconduct. So the test to be applied, which is probative value, where in this case, the prejudicial effect was that the witnesses were not conspired in order to take an action against the defendant, because they never knew each other. So under SFA, the probative force may be determined by looking at the similarities of the current misconduct in which the defendant is currently being charged for and the previous misconduct through the test of striking similarities. So in order for the plaintiff to take an action, the act must be of the same kind with the facts of issue, even it need not necessarily be in the same transaction, time, or place. So, as had been mentioned earlier, based on the principle in the above mentioned cases just now by my fellow friends, Botak Singh need to show that the disease suffered must be relevant and admissible under Section 14 and 15 of the Act. So, there must be balanced act between the probative value and prejudicial effect in order to tender the similar fact evidence to the court.
In conclusion, Botak Singh might adduce the similar fact evidence by bringing the three witnesses to testify as they had gone for similar hair treatment with the defendant. The evidence to be brought constitutes the strikingly similar with the offence with which the accused is being tried.